folks, it is another document. The lawyer for Rodalius Ryan she made a splash. This is Angela de Williams. She is the sole remaining public defender on contract. She is the one that deserves a whole lot of respect, because she only has this case because it takes up all her time. She's being paid $5,000 a month. Now that is not chump change, but for a lawyer for this, it's not a lot. So Mr. Williams takes Mr. Ryan's clothes home, washes them so he can have something to wear the next day of trial. That is how she takes care of her client. Now, this particular document is signed by Leah Abbasi and Angela de Williams. So, yeah, let's go ahead and just read it. All right. Dun, dun, dun. This is about the overt acts that Prosecutor Love wants in. And not only this is the overt acts that are not within the charges. They had this discussion a few weeks ago as well, that Miss Love really, really wants, because she must know she's losing, Miss Love. So now she wants in overt acts as intrinsic acts that is not within the charges. She claims to the court that the defendants can be held guilty under the RICO Act for stuff that is not in the RICO Act. And this is what these are opposed to. Memorandum of law regarding overt act requirement comes now. The defendant, Rodalius Ryan Jr., in the above styled matter, and submits to this court as requested the case law on the constitutional protection and substantial safeguards in place before the state strips a man of his liberty, that a defendant cannot be convicted solely on the basis of overt acts not included in the indictment. Ryan shows as follows. Count 1 of the indictment against Ryan alleges that he conspired to participate in a criminal enterprise known as Young Slime Life, which engaged in a pattern of racketeering activity outlined in 191 overt acts. The state claims that they need not prove any of these overt acts, and a conviction may rest solely upon an overt act not included in the indictment. The state urges this court to ignore not only the RICO statute in itself, but also centuries of antecedent development of common law going back to the Assize of Clarendon in 1166. Russell v. United States from 1963, explaining that the history and purpose of a grand jury indictment is to, quote, provide a fair method for instituting criminal proceedings against persons believed to have committed crimes. The Constitution itself, federal and state jurisprudence, as well as the RICO statute, require that the indictment contain the necessary elements, which includes the overt acts which form the criminal conduct, and the state must then provide evidence to prove the act which supports the charge. The states may not rely on whatever conveniently arises to create an overt act which could support a conviction. Doing so would violate due process. A. The Fifth Amendment right to indictment by grand jury protects the defendant from conviction based on acts not contained in the indictment. The Fifth Amendment of the United States Constitution provides that, quote, no person shall be held to answer for a capital or otherwise infamous crime unless a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. United States Constitution, Amendments 1, 5. Georgia Constitution, Article 1, Section 1, Paragraphs 5. An indictment including this indictment reflects what was presented to the grand jury. The grand jury may or may not have heard about the unspecified incidents that the state now wants to adopt as overt acts. Any conclusion one way or another about what was presented would be a guess. Quote, to allow the prosecutor or the court to make a subsequent guess as to what was in the minds of the grand jury at the time they returned the indictment would deprive the defendants of a basic protection which the guarantee of the intervention of a grand jury was designed to secure. Quoting from Russell. The language is clear and unambiguous. There is no alternative reading which would permit the state to try and convict Ryan for conduct which was not presented to the grand jury. B. The Sixth Amendment demands that the indictment inform a defendant of the acts which constitute the crime alleged. Dun, dun, dun. Oh. The Sixth Amendment provides that the accused, quote, the accused shall enjoy the right to be informed of the nature and cause of the accusation. United States Constitution Amendments 1, 6, 1 and 6. Georgia Constitution, Article 1, Section 1, Paragraph 6. Due process requires that a criminal defendant be sufficiently apprised of what he must defend against. Grant v. State, 227 Georgia App from 1997. Holding that a defendant was sufficiently apprised of the predicate acts where the indictment identified specific transactions by check number, date, and recipient. Kimbrough v. State, 300 Georgia 2017. Holding that the indictment must do more than repeat the language of the statute and must inform the defendant what he be prepared to meet. The state would like to completely dispel this requirement and rely on conduct not included in the indictment. The two requirements of an indictment are that it definitely inform the accused of the charges against him so that he may present his defense and avoid surprises at trial, and that it protects the accused against another prosecution for the same offense. States v. Pittman, Georgia App from 2010. Ryan is unable to prepare a defense to unspecified acts. By its own representations, the state is still trying to decide what evidence they will actually try to introduce to prove the 191 acts in the indictment. Yep. And even Judge Whitaker told this to the prosecution the other day, that it seems like Ms. Love is trying the case as it goes along. Remember, the prosecution said they were ready for trial in December of 2022. That is almost 2 years ago. And now Ms. Love every day comes to court unprepared. Every day. She lies to the court. She cheats and lies because that is how she tries her cases. And now everybody's time is wasted. So now she invents this with intrinsic acts that are not in the indictment, which is stupid. The state's position would require the defendants to identify the evidence relevant to acts which the state may not even have thought of, or which may not even have occurred yet. This would leave, quote, the prosecution free to roam at large, to shift its theory of criminality so as to take advantage each passing, I don't know that word, of the trial and appeal, quote unquote, a practice of the Constitution prohibits. Russell 768. C. The state must prove that at least one member of the alleged conspiracy committed one or more of the acts in the indictment. To prove RICO, the state must prove at least two of the predicate offenses in the indictment. case law, Dorsey v. States, where here the defendants are charged with conspiracy to commit RICO. Quote, a person may be found guilty of a RICO conspiracy if they knowingly and willingly join a conspiracy which itself contains a common plan or purpose to commit two or more predicate acts. The inclusion of improperly charged predicate acts, the equivalent here, overt acts not charged at all, will not void a conviction if two remaining predicate offenses support the conviction. Carby State. The inclusion of additional acts does not satisfy the requirement that the states prove an act charged. The state cites to Georgia v. Meadows and Pasha v. State for the proposition that the state need not prove that the defendant himself committed the overt act in the indictment, just that at least one member of the conspiracy did so. This is accurate and not the issue at hand. Those cases address who committed the overt act, not whether the indictment included the overt act at all. Any reliance on such cases would be misplaced. Yeah, Ms. Love quotes the law wrong, the statute wrong, as she has done so many times. So many times. D, to permit a conviction based solely on overt acts not included in the indictment would amend the indictment. A valid indictment must include all of the essential elements of a crime. A RICO conviction requires two steps. 1, proving a defendant has committed two or more offenses of the sorts included in the RICO statutes. 2, proving that the offenses have been committed as part of a pattern or racketeering activity. Carby State from 2019. With conspiracy to commit RICO, the first requirement no longer applies. Instead, the state must prove that the defendant joined a conspiracy in which some members performed the second requirement. While the defendant's degree of participation is lessened, the underlying acts must still be specified. The present indictment meets the first requirement by listing the 191 overt acts, which allegedly constitutes an offense within the RICO statute. If none of these overt acts are proven, there can be no conviction. If the state would like to add to its list of 191 overt acts to satisfy the required elements, the forum for doing so is before the grand jury, not mid-trial. Permitting acts outside of the indictment to support a conviction would amend the indictment. Amend the indictment here means it would more or less disqualify the indictment in whole. That seems to be the argument. This court cannot authorize a jury to convict for conduct outside of the indictment. This court will be required to instruct this jury what the state must prove. These instructions must limit the jury's consideration to the elements of the offense as charged in the indictment. Holman v. State, 2014, holding that the trial court erred when it instructed the jury that an organic brain injury could sustain the manner of homicide when the indictment specified that a part of the body was rendered useless. So I don't know that case. Where RICO could be committed in multiple ways, the instructions are still limited to those in the indictment. Before the opening arguments in this trial, Judge Glanville spent 4 hours reading the charges. 4 hours. It is so stupid. To apply the state's theory, this court will have to instruct the jury to ignore this element of the offense. F. The state has provided no authority to support their contention that the indictment need not include the overt act to sustain a conviction. The state provided to this court a list of cases which include the phrase that the indictment need not set forth the overt acts. However, that is not the holding of the case cited. Ooh, I need to see that one. Footnote 3. The great irony of the state's argument is that it urges this court to go outside of the specific phrasing of the indictment and consider everything in totality, yet also urges this court to focus solely on a specific phrase from case law versus consider the issue in totality. Particularly, the state points to footnote 13 in Kimbrough, but ignores the holding. Where were we? There. The relevant issue is whether an indictment meets the constitutional due process requirements. The state cites Nordahl v. State, which indeed does say that the states need not prove the overt act in the indictment. However, the Georgia Supreme Court cites to United States v. Kaplan, which clarifies that an overt act besides those specifically named need to be encompassed in the indictment to the extent that the defendant was on notice that those acts could be offered against him as proof of the indicted offense. The Second Circuit went on to further clarify that reliance on uncharged acts can amount to a constructive amendment or variance, which would reverse that conviction. In Kaplan, the indictment charged Kaplan with false statement based on representations he made to FBI during a post-arrest interview and identified specific portions of that statement. In closing, the government asserted that Kaplan's statement contained 7 misrepresentations, only one which has been specifically identified in the indictment. The indictment sufficiently informed Kaplan that what he said during a specifically identified conversation formed the overt act towards the false statement charged. Additional content from the same conversion was no surprise. Here, the state urges this court to read a single sentence as carte blanche blessing to permit conviction based on whatever overt acts the state comes up with. Neither the defendant nor this court can determine right now whether these other acts amount to amendment or variance, because those are post-conviction inquiries and the uncharged overt acts have not been identified. State provided the case of United States v. versus Jimenez, relying on, out of context, the phrase that evidence is not limited to the overt acts in the indictment. This is true when examining the sufficiency of the evidence presented. Jimenez was charged with conspiracy to commit money laundering by committing fraud under USC that number, which involves immigration documents. On appeal, he argued that specific documents listed in the overt acts would not constitute a violation of the law. Thus, evidence was insufficient. The court found that 1. The indictment did name specific documents which supported false statements. 2. When reviewing sufficiency, the court looked at all the evidence presented. The issue here is not sufficiency of the evidence. It is the due process requirement that Ryan be appraised of the conduct giving rise to the indictment. Jimenez did not, nor could he, argue that the indictment did not include the conduct which constituted a crime. ID. The documents which support a conviction were specifically included in the indictment. Jimenez had ample notice of the evidence he would need to confront. And this basically means that Ms. Love argues to the court that she doesn't have to present documentation, that she doesn't have to give warning, that she doesn't have to present the case to a grand jury. She can then add shit on as she goes along. That is not the law. It simply isn't. The state provides to this court a number of cases from the Supreme Court of the United States and State of Georgia, which holds that due process requires the indictment to provide specific information about the conduct at issue. The word attempt, coupled with a specification of the time and place of respondent's attempted illegal re-entry, satisfied both. Indeed, the time and place information provided respondent with more adequate notice than would an indictment describing particular overt acts. These cases not only contradict the state's claim that they need not prove the overt acts listed, but instead supports Ryan's position that the indictment specified the overt acts as at issue. Conclusion. The state's contention that overt acts solely outside of the indictment not only ignores the law, but also offends a fundamental notion of fairness. The state has no reason to argue that overt acts outside of the indictment alone will sustain a conviction unless they need to rely on this premise. The state would only need to make this change if, as trial progresses, it becomes evident that the state cannot prove its case. Yeah. In plain language, they know they're losing, and now they are trying to add in new stuff. And you can't do that. The state has a duty to pursue justice, not a conviction. True. As the state watches their case fail, they refuse to accept the possibility of defeat fair and square, but rather seek to make up a new case as they go along. No defendant can prepare to defense against allegations which are being invented as the trial goes along. Such a demand would render, quote, due process meaningless. However, that seems to be the door the state wants to keep open throughout this trial. If these overt acts aren't working, just add some new ones. That is neither legal nor just. Respectfully submitted, October 9th, by Leah Abbasi and Angela de Williams, Esquire. And certificate of service. In plain language, judge, they are cheating. Please tell them to stop cheating. Yeah, so that is the documentation, the Memorandum of Law regarding overt act requirement from Angela de Williams and Leah Abbasi. And it is again, I say this word a lot, unfathomable. I cannot understand how this can go on. Judge Whitaker, please. You've already seen Miss Love lie to your face. You have seen Miss Hilton lie to your face. They make stuff up. They lie to you. They cheat. They hide things. When is enough enough? It has to be enough. It should have been enough with the deportation of Judge Glanville. It should have been enough. So please, Judge Whitaker, please grow some spine and throw this case out. Okay, that was the reading of that document. See you later. Have a nice one. Bye-bye.